Good morning. My name is Michael Erdl. I'm one of the members of the board of ADRIC, and my pleasure to introduce the speakers for this session on deal mediation. The moderator is Stephen Morrison, who needs no introduction if you were at the previous session, which he also moderated, but he's a full-time resident commercial mediator and arbitrator at Arbitration Place here in Toronto, and many of the disputes he's retained for it involve real estate, construction, infrastructure, environmental claims, and leasing issues. Next to him is Ed Waitzer, Stikeman Elliott. He's a senior partner and former chair of the firm. His practice focuses on complex business transactions. He is a professor at Osgoode Hall Law School, in chair of corporate governance, and at the Schulich School of Business. And next to him is Wuraola Dasylva. She's a Nigerian-trained lawyer and a graduate student at the University of Manitoba. Her master's research focuses on the use of ADR processes in Canadian mergers and acquisitions practice, and she'll be discussing her research findings. And last but not least, Garrick Apollon has 10 years of legal experience as a corporate lawyer, mainly acquired at the Department of Justice in Ottawa. He has been a part-time professor at the Telfer School of Management, MBA, and undergraduate programs since 2005. So looking forward to what all of them have to say about deal mediation. Okay.
Thank you very much, Michael. I'm going to start things off by saying what I said at the beginning of my last panel at 9:30. And that the panelists here are a hand-picked group of people. I say that because I hand-picked them myself. And they were selected for various reasons. About a month, 2 months ago, I don't remember, Wura, but I got an email from a graduate student at the University of Manitoba asking if I would be prepared to participate in some research she was doing for her master's thesis. And it was on this topic, deal mediation or transactional mediation, which coincidentally I had written an article on a few years ago. And I said, sure, by all means, because at the very same time I was talking to the ADRIC organizing group for this convention on doing a panel on deal mediation. And there was Wura showed up, and she was literally doing this research. So I thought, what a great idea. Let's ask her to be on the panel and tell us about her research. Garrick Apollon is, as you heard, with the Department of Justice, with the Government of Canada, excuse me, also a professor at the University of Ottawa, and somebody with significant experience in both domestic and international and cross-cultural transactions. And again, Garrick has written a lengthy paper on cross-cultural mediation, which is included in your materials, and we're not even going to get to touch on most of what's in there during this session, but I've read it beginning to end, and I commend it to you. It's full of useful insights into this process. And last but not least, we have Ed Waitzer, whose brief introduction didn't do justice to his career. Ed would be one of the leading commercial lawyers in Canada, as well as having chaired the Stikeman firm, and as well as being a full-time professor at Osgoode and member of the faculty of other places. As he said earlier, he's got a lot of full-time jobs. He also chairs or organizes the joint MBA JD program up at Osgoode and Schulich, and is just, and I guess also I should mention, a former chair of the Ontario Securities Commission for a 3-year period, I believe. So Ed is steeped in commercial law, and I thought who better to provide an opinion of senior counsel to this whole concept that we're going to discuss. The topic of deal mediation is probably something no one's ever heard of in the room prior to today, because it's simply something that has gotten no traction almost at all in the Canadian context. Gets a little bit of traction in the US, a little bit in Britain. Wura can tell us more about that in a few minutes. But it's essentially an unknown concept, but one which I suggest its time may have come, and it may be something that more business people may want to consider going forward. We'll talk about some of the reasons in a moment, but just by way of background, those of you who have been involved in the world of mediation for a while will know that in January 1999, the Government of Ontario introduced mandatory mediation for most civil actions commenced in this province, initially in Toronto, then it was extended to Windsor and Ottawa. Today, mediation in the resolution of commercial disputes, court cases, is pretty much de rigueur. There are very, very few cases that will go to court without having had a mediation, and as a result of mediation, very, very few cases go to court. And even in parts of Ontario where it's not mandatory, my experience is that parties are adopting mediation almost as a standard feature of the civil procedure process, whether they have to or not. Consequently, only 3 to 5% of cases started in Ontario end up in the courtroom, which is a great success rate. Not all of them settle because of mediation. Some get abandoned, some get settled between lawyers, but a lot of them are mediated to a resolution. So what we're going to be talking about today is bringing this tool, which is used effectively in some areas of commercial enterprise. We all know that mediators, or sometimes they're called conciliators, are involved in labor relations contracts. They're involved in a few other areas by government from time to time. But the idea of two parties wanting to sell a business, merge two businesses, enter into a 50-year lease agreement, just a few examples, enter into a large franchise agreement. You know, they just don't think about bringing in a mediator at the initiation of the process to help the process achieve a successful conclusion. And that's what we're going to be talking about today. What are the... There's a little switch at the side. Do you want to just that'll turn off the ringer. Good. That's why you need a mediator. Somebody I know once said, please check your phones, make sure you've turned them off. And then they also said, "When please check the ones that you've turned off, because those are the ones that usually go off." In any event, so we're going to talk about the kinds of dynamics that go on in a transaction that might benefit from the involvement of a mediator, the kinds of transactions. We're going to be talking about the impediments, like why hasn't this tool that has been so successful in dispute resolution morphed over into the world of transactions. We look at transactions, for example, a number of years ago, one party wanted to buy a controlling interest in a major airline. The deal didn't happen. Maybe the deal wouldn't have happened if there'd been 10 mediators involved. There may have been sound business reasons. But so many deals don't come to fruition, or come to fruition in 6 months instead of the 90 days that everyone thought, because issues arise, and we're going to talk about some of those issues and how a mediator might be of benefit, and we're going to talk about where the resistance will come from to using that idea. So the first piece of this is I was going to call on Wura to make a short presentation on the research she did, but also to add a little bit about why she did this research, what got her interested in this area, what she's discovered in terms of perhaps other jurisdictions, and then what her own research process highlighted for her. So over to you, Wura, Dasylva.
Thank you very much. Do you mind if I use the
No,
podium?
please,
Okay,
please.
thank you.
The podium is yours.
Thank you, Stephen. Thank you, everyone, for taking time out to be here this morning. I'm very humbled to be part of those that will be speaking on this interesting topic this morning. My expertise can never be matched with all of these amazing persons on the panel, but I still feel very humbled. And so, like he said, my name is Wura Dasylva, and I'm a Nigerian-trained lawyer. I worked in a law firm as a corporate lawyer, and I was involved in a couple of transactions, and I was familiar with the contract, the document having the arbitration clause, the mediation clause. But one thing I realized was that they were hardly invoked. And so when I wanted to proceed to have my master's program, I felt, what better area to do my master's program in other than ADR processes and corporate and commercial transactions. So I realized that there's a bunch of corporate transaction and corporate law materials and scholarly articles on the one hand. There's a bunch of ADR processes articles and scholarly write-ups on the other hand. But I realized that there's a very tiny bridge of literature connecting them. So what it means is that very few people have written on the area of ADR processes as it relates to commercial transactions. And so I spoke with my professor, who is Professor Schultz. She's not here this morning, but she's interestingly one of the members of the board of the ADRIC. And she said, oh, yes, this is a great idea. Why not do something that only very few people have done? Maybe you're going to be the first person to do it. Why not speak to practitioners and see the extent of use of ADR processes in Canadian mergers and acquisitions processes? Because the specific transaction that I'm examining is mergers and acquisitions, but complex and large commercial transactions in general. So I set out to get participants who would like to talk to me. And the reason I wanted to talk to people was that I realized that many researchers, especially at the master's level, would typically be reviewing other articles, rewriting, criticizing, so I wanted something more. So I adopted a qualitative research methodology, which is different from quantitative. Qualitative deals with the quality of information provided. It deals with the kind of information you're getting, and that's where the strength comes from, as opposed to quantitative, which has to do with the numbers. So I didn't get very many persons to indicate interest in my research. Unfortunately, many people are busy and all of that. But then I got a few people who had interestingly engaged in hundreds of commercial transactions, which made me feel good. And my participants were from Toronto, Vancouver, Winnipeg, my home city, and Regina, where my family is based. So maybe it was easy to get even practitioners from those little cities too, who had very meaningful things to contribute. And like I said, they had engaged in hundreds of transactions. Now, one thing I observed was that this is largely theoretical, but then I was bringing a practical perspective. The practicality is not in the fact that this has been engaged in any transaction before. Interestingly, all of my participants in all of the hundreds of transactions had never engaged a deal mediator before. And you'd be amazed at the research findings at how very many of them think a deal mediator would not be bringing anything to the table. And I hope that this discussion would probably unravel the many benefits of deal mediation, and maybe it's something that will gain traction in Canada, probably not immediately, but maybe in a few years' time. And so when it comes to the US and Britain, I found out that there's a lot more literature on deal mediation in those jurisdictions more than we have in Canada. But like I said earlier, that something is written on paper does not necessarily mean that it's being practiced. So I didn't have the opportunity to interview practitioners from those jurisdictions, but from what I found in literature, I realized that US is very accommodating, and over time, it's gradually gaining traction. There are even mediation firms who specialize in actually coming into large commercial transactions and who are engaged. In Britain, it has gained a whole lot more traction than it has in Canada. I mean, in Canada, it's almost zero. In Nigeria, in Canada, I'm saying it's almost zero because we still have someone like Stephen Morrison who can probably find his way into a transaction if he could and be the deal mediator. But in Nigeria, it's zero. And that's the truth with many other countries in West Africa. So the research findings, which I would quickly just say in very brief points because of the time, I realized that it's a novel concept, very novel. So only very few participants got the idea. I mean, it makes sense to say deal mediation. I mean, common sense will tell you this is what deal mediation is. So it's when you have a neutral third party facilitating the process of a transaction from start to the end, meaning even from the bargaining stage, from the pre-contractual stage, having that person who is a neutral third party engaged from the very beginning. So what this means is that even at the point when there is no dispute at all, you are engaging this party so that you wouldn't have disputes. And if there are disputes, which disputes are bound to happen anyway, it wouldn't boomerang, and then the mediator can quickly try to curtail it with the help of the other professional parties in the team. So it's a very novel concept. Like I said, my participants got a sense of it, but I also had to explain a bit more to them what this means. Also, none of them had experienced that, not personally in the transactions that they were engaged in, and not in hundreds of other transactions that they had their colleagues engaged in. So they gave different reasons. 80% of my research participants think that cost is a major thing. Why would I tell my client that I need him to bring in one more person into the deal team who is definitely not rendering the service pro bono and who has to be paid, and I'm definitely not paying this deal mediator from my own professional fees? I mean, how do I convince my clients that this person is so important that we need him in this deal? So cost is one thing. Another second one is the fact that almost all of them believe that a mediator is playing a redundant role, which can be provided by the legal practitioner or even by the investment banker. So the question is, we've done lots of other deals in the past, and they were successful, and we didn't have a deal mediator. So why now? So I think the fact that it's also a very new area also makes them think, I mean, if we had successful deals in the past, why do it differently now? A few of my research participants think, where would you get such a qualified person who would not only be a skilled mediator, but who would also know so much about the transaction at stake? We don't want someone who is a skilled mediator, who is a mediator by name, but that we have to bring up to speed when it comes to the dynamics of the transactions, the nitty-gritty of this is the real estate law that's applicable, and this is how we want to invoke this section of the law to favor the client, and all of that. So how do you get a deal mediator who is so grounded in that area of the large complex commercial transaction, who knows the tax perspective, who knows this perspective and that perspective? Also, one of my research participants thinks that the type of companies would determine whether ADR process would even be useful or not. So I heard someone say that if it's a public company, they would typically want to go to litigation. It's usually contentious when there is a dispute. But then why would you have a deal mediator in a public company transaction, a transaction involving public companies? I hope someone on the panel would probably shed more light on whether or not a mediator can be useful when it comes to public companies' transactions. So maybe 70% of them, yes, 70% of them think that mediation would work when it comes to resolving post-closing issues, employees, all of those things that would have to do with, now that we've done the legal part, now that we've signed the papers, it's time to move on, it's time to implement, it's time to ensure that the relationships stay well. So maybe we can have a mediator at that time, but definitely not in the process of the transaction or not at the bargaining stage. So I was particularly thrilled with what one of the research participants said, which was that many investment bankers, many lawyers are naturally motivated to see a deal close, because that's the joy of your client anyway. That's your joy, because you eventually make your client happy. So if I'm naturally motivated to see the deal close, why do I then need a third party to motivate me or to make this thing work faster or make it easier and all of that? So one thing that all of them probably agreed on is that ADR processes are underutilized in the global marketplace and even in Canada. So, in conclusion, I think the traditional notion of mediation is what has precluded many people from seeing mediation as something that can be, as a dispute resolution tool that can be used in large complex transactions. And I hope that because of panels like this, because of opportunities to learn more about this, hopefully in the next few years, maybe deal mediation will be something that everybody would see as part and parcel of a transaction, and maybe a deal mediator would also become a member of the professional team or a member of the deal team in many transactions. Thank you very much for listening.
Thank you, Wura. I wanted to just pick up on one of the points Wura made, which is the involvement of the deal mediator from the beginning, and just briefly touch on the notion that when deals get done, they typically happen in phases where business people or investment bankers may identify two parties that want to do a merger, acquisition, divestiture, whatever, and you end up at some point with either a letter of intent, a memorandum of understanding, usually some non-binding document that maps out the basic terms of the deal. Then you enter into a period of due diligence where the parties are investigating various issues. We'll talk about a few in a moment. While that's going on, the lawyers may be working on a comprehensive agreement, which would set out all the deal terms. And then you move from that point to closing, where you're doing all of the documentation to transfer property, both real property and physical property, amending contracts and so on. And then you get to your closing. And then the final stage is you would have post-closing adjustments or post-closing disputes in some cases around issues that have arisen. So, you know, I came to this whole concept because between two legal careers and now a neutral career, I spent 20 years in the business world, and at various times we had 5 public companies that we controlled, and we were constantly doing deals, buying companies, merging companies, selling companies. And I saw all the different ways in which these deals could fall off the rails, whether it was a dispute over valuation of inventory, real estate, fixed plant and equipment. There would be environmental issues that would come up, would be discovered in the middle of a deal, contingent liabilities, past service obligations to employees, union contracts, and so on. And, you know, the parties would start getting together. They might bang heads. The lawyers might bang heads. Things could grind to a halt. It would take a long time to get them resolved, and there was never anyone to go to act as a middle person, to try and move it along more quickly or help the parties resolve the dispute. And I often thought that would be a good thing. And one of the things that I'd like Ed to comment on in a moment is if you don't have that person in the middle of the transaction helping the parties, then inevitably what happens is one party's lawyer or the other ends up having to be the conciliatory lawyer. Otherwise, things can grind to a halt. Well, my experience is it's very difficult to be the conciliator, in effect the mediator and also the advocate for your party. You end up compromising more to keep the deal moving forward if you run up against a party on the other side that's more hard-headed or difficult to get along with. Is that a phenomenon, Ed, that you ever see in practice where, you know, one side or the other really has to play that intermediary role or the deal's going to fall apart?
You probably see it more on smaller transactions that are less lawyered up or professional up. So, you know, on a larger transaction, first of all, there's a bias in transactional work to hire lots of experts, because under corporate law, expert advice provides management and the directors with a shield against liability. So on any significant transaction, the bias will be to load up with experts. Any good transactional professional, and I put in that category lawyers, bankers, sometimes accountants, but certainly the lawyers and the investment bankers should have, if they're going to be effective, significant negotiating and mediating skills. They should understand the kinds of cultural contexts that Garrick speaks about, the heuristics that are critical to understanding how to get to a negotiated consensual transaction, including the hubris of clients who, 85% or whatever the number of deals don't work out in the end. And that's a result of a bunch of the heuristics that Garrick speaks to in his article, and transaction professionals should understand that. So to come to your question, that in a normal sort of large public company transaction, somehow that ecosystem sorts out. So you'll have a bunch of specialized lawyers dealing with various aspects of the transaction. Often someone like me who isn't very specialized but sort of supervises the team.
You're the quarterback.
Same thing on the investment banking side, and same thing within the company. And as disputes arise, you sort of strategically or organically figure out who the right person is to sort of move things forward. And that person will play what you would describe as the mediation role. So you tend, so sort of, have I seen situations where the collective group says we really need to bring somebody in from outside because all of us are carrying too much baggage or have too much invested in our existing roles? Yes, but tends to be the exception rather than the norm. And the challenge then becomes, how do you get both sides to agree to layer in another sort of professional actor in the process? On the back end, just to finish off, in most of these transactions, dispute resolution is arbitration by contract.
Right.
So it sort of short circuits the mediation process that you described in the introduction, because it just doesn't go there.
Well, one of the problems is I invited a good transactional professional to be on the panel. Not all transactional professionals are as good as Ed. And Ed, surely you must have situations where, because you don't get to choose the other side's lawyer, you get somebody on the other side of the transaction that is a stumbling block, that is difficult, that's hard-headed, that won't budge, that, maybe you've had a history with that person, maybe that person's had a history with your client, where the usual quarterbacking that you do is just proving problematic.
What's interesting is that in Canada, just because it's a relatively concentrated community, you actually do have a lot of influence on choosing the other side's advisors. It's just, we would all rather work with good professionals on the other side, so there's a lot of self-selection within the community, both on the investment banking and on the legal side, much less so in the States. My comment, though, on the States would be, and this is a cultural observation, in the States, transactional work is a contact sport. Mediation is not something, I can, to give you an example, and I won't go into the details, but I was advising the board of Imperial Oil, which is a controlled subsidiary of ExxonMobil, and there was an issue between Imperial Oil and ExxonMobil. And I reached the end of my string and went to the general counsel of ExxonMobil and said, why don't we get a mediator? Pick the person who you think is the most knowledgeable subject expert on this particular topic, and we'll let them mediate and, if necessary, arbitrate. And the answer was, you don't get it. And the ultimate conclusion was, the chair or the lead director went down to meet with the CEO of ExxonMobil, and I got a call the night before the meeting where I was told, Ed, here's what's going to happen. You know, Sheila is going to hit Rex. Sheila was the lead director of Imperial Oil. Rex is the CEO of Exxon. As hard as she can. Rex is going to hit her back. One of them is going to be left on the floor at the end of the discussion. And then they're going to get up and they're going to be friends again because, you know, it's like football. That's how we do things down here. So you know, culture does matter, and in Canada there's a lot of self-selection, and in the United States, mediation is something that most would dismiss in a transactional context. And again, I'm overgeneralizing because there are always opportunities for what you described.
It makes me think of back in 1999 when mandatory mediation was brought in, old school litigators. Why do we need a mediator? We've been settling cases our whole life. We go to lunch, we have a drink, we have a martini, you know, we settle cases. Why do we need mediators? Well, it took a long time, but that resistance has disappeared.
Well, and I'll give you two. You will sometimes see in transactional work someone being retained not to do the work, but sort of as independent counsel to the board, for instance. And their job isn't to do the deal. Their job, and they don't have the team behind them to be able to do the deal. They're retained because of their judgment and instincts. And they're just there to give the board advice and the professional team a sort of shake your head every once in a while. The other thing that you see sometimes is a lawyer, and I've had this a few times, getting a joint retainer. So being asked to act for both sides, and again, there will be teams on either side, and the engagement agreement provides that at any point, if either side thinks there's a conflict, you get blown away.
But aren't you the deal mediator there?
But that would in effect be a
Right.
deal, that's getting close to what you describe as a deal mediator.
You know, in construction projects, large ones, they often have, well, it's a provision actually in all the standard construction contracts that the parties will, within 10 days of signing the contract, appoint a project mediator. Now, that person is just appointed in case they're needed. They're identified at the front end, and you go through many projects, they're never called upon. But if an issue comes up during a 3-year construction project, they're on call. They come in on short notice. You don't have to argue at that point about who it's going to be and get into all that, you know, who are we going to get? And it comes in, resolves that issue, the money keeps flowing on the construction project, and the deal goes on.
Yeah, another analogy. Solvency proceedings. 'Cause
Exactly.
The monitor is, in effect, the honest broker.
But Garrick, and then this comes back to the issue of resistance by lawyers to one of the points you make in your paper is that parties often have an negotiating skills. Do you want to elaborate on that a little bit?
Yeah. We're not always loved by people. We're viewed as people with big egos, and all the research that has been conducted. So about the need for cross-cultural deal mediation or deal mediation, in the context of international business transaction, I mean, research shows that 50% of international joint venture fail, and 83% of cross-border MMAs fail. So lawyers can think they're great, but something is not working because they're the one drafting, negotiating the agreements, the contracts, and they're not always viewed as durable, efficient in terms of preserving the contractual relationship between the parties. But it's also the culture. Legal education is based, and I mentioned in my article, another article from a woman, a legal scholar, published that says that it's known as the gladiator culture, where it's tough, you have to be assertive, you have to have rigor, analytical rigor, and also confidence. We're taught to be confident. Who wants to have a lawyer? And you make the sports analogy. I played college football at Laval University, and I didn't have the chance to play quarterback, but when I started to practice law, I love to be the quarterback of commercial transaction. So I mean, I had a very team approach. I learned that from football. I work with my clients I work at Transport Canada, Department of Natural Resources, and I got involved the engineers, the policy analysts, everybody. It was a team effort, and always have a solid understanding too that we were working to serve the Canadians, not serving ourselves to look good at the end of the day. So that was an humble approach too. But it's not always the norm, and I can say from the Government of Canada perspective, just the business of transfer of payment, like financing agreement, contribution agreement, it's $43 billion in economy. I mean, when we work at Transport Canada during the Economic Action Plan, we're a small team of 5 commercial lawyers, and we did transaction for $11 billion in 2 years. I mean, it's a lot of money. And often the minister will say, I want that agreement to be signed yesterday, because that was about the stimulus package for the economy. Guess what? If you're negotiating with a public sector entity, as a Fed, I can tell you, we negotiated with one province who see themselves as a sovereign nation. I'm from there. And Alberta, who was oil-rich money. And of course, with First Nation, also, that was a sensitivity because of history in Canada. So it was really tough negotiation and really long, and a deal mediator who had been accountable because the process was controlled by bureaucrats, by lawyers working for the government, but nobody really reported to the elected officials, the minister. A deal mediator will be there at the table to hold accountable everybody at the table to the minister. So that will really be a game changer. I mean, in the public sector context, but I can see that also in private sector when you have a big cross-border transaction and the investors, you talk about that, Steph, in terms of it will show also diligence from the company to get involved, someone to make sure to reassure the investor that was conducted in the best interest of the investors.
When I was in the business world, one of the things we did was we often thought of deals in one of 2 categories: the deals that it would be nice to do and the deals that had to get done. And the ones that would be nice to do, I suppose, they happen, they don't happen. You might spend some money trying to get the deal done, but if it didn't come together, you'd go on to there'd be another bus that would come along. And then there were the deals that for some reason, it was incredibly important to one or often both parties that the deal be consummated. And while that was a driver, it also put a lot of pressure on the parties. And I would see those as deals where bringing an intermediary in at the beginning of the process to ensure or help ensure that the deal gets consummated has particular value. And when you mention the idea of the minister who says, I want this signed yesterday, and there may be political reasons why it has to happen, again, this would be a situation where it would be particularly important to have somebody quarterbacking the process who wasn't involved with either party in particular, but was there to facilitate getting the deal done. Do you see that, Ed, as a situation where you might be more inclined to see value in this process? See, I got to turn Ed around by the end of this section.
I'm wide open, but it's so much of this is context specific. So,
of course.
In the right context, what you described makes a lot of sense. So let me be the devil's advocate, which is in the wrong context. Anytime, there are a lot of professionals around a transaction whose job it is to get it done. Anytime you bring in another layer of professional advice, the risk is that you're diluting focus and diluting accountability and complicating the decision-making process because, as Garrick points out, professionals have egos, and everybody wants to demonstrate that they're contributing to the transaction process. And you know, the job of the quarterback sometimes is to keep all of that in check and kind of make sure everybody's ego is being satisfied on the way and making sure everybody gets. So the risk of bringing in someone else can often be that it will have the opposite effect of what you've described. And that depends on the context, it depends on the dynamics of the people involved. It's very hard to generalize.
Isn't that, if I can just offer a comment, maybe, isn't one of the complications we face, I mean, I love Americans, we're very similar to Americans, but we're very different from Americans. When we wanted to form a country here, we asked the Queen of England, we've got 4 provinces, we'd like to be our own country, and she said yes. In America, they had to fight a war of independence to become a nation, and 90 years later, they fought another war to keep it together. And that's my first point, that Americans are the litigious by nature because they're hardwired from how their nation was formed to be that way. The second complication is costs mean nothing in the US of A. Everybody pays their own costs. So when you talk about inserting a mediator into a complex transaction in which perhaps one or both parties are American, and you say to them, well, you'll save these court costs if you don't, you won't pay the winner's costs if you lose the case. That means nothing in the US of A. Costs mean something in the litigation sense in Canada, and they certainly mean a lot in England, where the loser may pay 85% of the winner's costs. So I wonder if there's a perception when you're dealing with an American purchaser, buyer, that there's not much value in adding a mediator because, we'll just go to court and everybody will pay their own costs, winner or loser. So why is a mediator value added, at least in the sense of saving the cost of litigation?
So in the deal context that I think Steve was, it's before you get to litigation, and in that context, costs tend not to matter to anybody, right? The costs are going to be a relatively insignificant number,
Including the relatively small cost of a mediator.
Agreed.
Yeah.
So cost isn't going to be a factor in deciding how best to staff the transaction or get it done. I agree with your observation, and it essentially mirrors what I described, that Americans are more confrontational and Canadians are more consensual.
Well, I have an answer. Maybe I talk about it in my article.
Come back to you.
It was actually published in an American Law Review, Law and Business Review of Americas, and it's a law review affiliated with the American Bar Association. So, meaning that there's the American Bar Association International section saw practical values in promoting cross-cultural deal mediation to their members, to their practitioners. They didn't just see that as an academic argument or something. But from the American perspective, the idea of my paper, actually, it was a couple years ago when I went back to school for my second master at the University of Pennsylvania Law School in my class of international business transaction. And my professor really helped me and said, in the American culture, why it could be valued is exactly what you said. It's like it's always litigation, fighting, spending a lot of money in litigation. But he said the way we were trained as international lawyer to work on international transaction was that if you can show your client that, the best, because often corporate transaction like a merger acquisition at the international level or domestic level, and then or an MMA is viewed as a corporate marriage, and it should be sold like premarital counseling. That the best marriage that the best divorce that you get is the one you get before to get married, and that wise, lawyer advocate for their client will, promote that, especially when it's complex transaction like Ed do, or, you know, cross-cultural transaction where culture is often an impediment. Like if you're negotiating with Chinese, or I did my article in Argentina with South Americans, they're very different than us, like in the way they think and practice law. So it could be, so there's, I will say in defense to Americans, they see practical value in that, and that was part of
Yes, actually, the American Bar Association, they've had sessions in their conferences where they were actually promoting deal, like something like what we're actually doing here, and they've actually had publications to trying to promote deal mediation. So I agree with you that maybe this has not gained much traction, and maybe, like I said, this is literature, because I've actually not interacted with American lawyers to see if the to get the point if they see value in this. But based on what I get from literature, which is what I can hold on to at the moment, I think they see some value in it. Maybe. I think so.
You had a question or a point?
Well, I was going to offer
Well, you know, in my perfect world, I'm not going to answer that directly in a construction context, but in my world, when all the Ed Waitzers of the world have been convinced that this is a useful thing, at a very early stage, the parties would say automatically, okay, we want to do a deal. It could be a construction arrangement. It could be a merger, acquisition, divestment, whatever. 99-year lease arrangement. And they would say, okay, well, who are we getting as our mediator? And that would be an initial question. It could be before price had been determined, because there could be a due diligence that would have to be done to finalize the price. The deal mediator would be engaged at the very beginning so that neither lawyer had to quarterback anything. And the deal mediator would sit with the parties and their lawyers and map out the process. How many, what do we need, 180 days, 60 days, 90 days for due diligence? What are the stages? Who's delivering what reports? Who's getting the environmental report? Who's doing the property valuation? Who's doing the inventory valuation? When will those be delivered? And he creates a schedule. And it's the mediator's job to make sure the parties are complying with the schedule. So he's checking in constantly to make sure that's happening. As issues come up, initially the lawyers talk to each other. As soon as they see they've got a roadblock or a problem, instead of getting further engaged in it, instead of getting further entrenched, or instead of letting it fester and not get resolved, one or the other, under instructions, they pick up the phone, they call the mediator, here's the problem we've got. Can you help us? He talks to both sides, gets a resolution, they move forward. Similarly, you know, so he's making sure the deal is not only getting done, but all the steps are being done in accordance with the schedule so things don't drift. Then as they're doing the master agreement or the comprehensive deal agreement, again, helping resolve wording issues that come up. You know, I've been involved in too many of these transactions where you sit around the table with 12 lawyers and you argue about a phrase in a one clause of a contract endlessly. These things can be dealt with, I think, a lot more smoothly with a neutral party in there trying to help the parties see that a position they're taking may not be that sensible. And stays involved through the closing, and then is available to help the parties work through post-closing adjustments or disputes so that they don't have to run off to arbitration, which is what these agreements typically call for. So in my world, it would be beginning to end, which doesn't mean it can't be, you can't introduce a mediator at some point along the way, but the cost of that person's services divided by the parties equally would be a significant number, but negligible in the context of the kinds of transactions I'm thinking of. So I don't know that that addresses your question, but Tony, you had something?
Yeah, just pick up on two themes here. Just following up on what Garrick was talking about, sort of the concept of the best divorce is the one that you've had beforehand, right? And I'm wondering, even just, do you start with a presupposition that all deals need to be made? And I'm wondering if you could compare and contrast the difference maybe between a dispute mediation where something is ending versus a deal mediation where something is starting.
That's a very good point. But what I was trying to show is that the role of the deal mediator is not necessarily to get the deal to be closed, like especially in an international transaction where you might not have any cultural synergy between the party, or they have nothing in common. So the role of a good deal mediator will also be to advise, say, you may want to revisit your decision to make this deal. So that's quite a good point that you made. Like, a good deal mediator will be there also to, because it's not necessarily about closing the deal all the time, but it depends the reality. In the public sector, when someone has been identified as a recipient, a proponent to receive government funding, there's no way out. And often they have a lot of leverage because they know, like, the agreement don't always get signed before that the announcement is made, but often after. So that's where a deal mediator will be useful too.
So Ed, would you welcome a deal mediator that was trying to undo the deal because he didn't think it was such a good idea?
No.
No, but you know what? Like when you described your ideal world,
Yeah.
I love that ideal world because I like
can
that
just-
job. That would be.
Well, I
but
told you
it's-
you'd be the
but
guy.
But a lot of what you describe in your ideal world is already baked into existing processes. So, and I think of facilitators as different than mediators, and we may be using a different term, but, you know, there are facilitators, in every deal, there are facilitators. There are, you know, politicians who, or whoever, who have relationships, and you use them for very specific purposes in the context of moving something forward. The one, and this is, I'm sort of walking out on thin ice because I'm really
It's all right, we're all friends here.
no, I'm straining to think about contexts where deal mediation might work, and, you know, we all come at it from our own particular perspective. But when you're talking about contracts, I'm not a contract lawyer, but I like to think about the trajectory of the law, and what I see in contract law, think of the Basine decision, Supreme Court, but I can give you lots of other examples, is increasingly the courts, actually in contract law, but in almost any area, public or private law, looking to reasonable expectations as informing, whereas lawyers, most lawyers, again, in the contract law context, are sort of very focused on the language of the agreement, and there is often a dissonance there in the quality of advice that clients are getting, and maybe that's the kind of situation where someone external could provide useful advice to the parties at the outset or somewhere along the way, saying, yeah, the language is one thing, but that's not necessarily what the courts are going to look to if this turns into a dispute. And the dispute may not be between the two of you. Incidentally, the dispute may be a third party asserting rights under the contract that you're not even thinking about at this stage. So that kind of broader view is something that a mediator might contribute, or what you call a mediator. I wouldn't call them a mediator. I'm not sure what I would.
Well, you just don't like the word.
No, I love the word.
Overcome some of your struggles.
Stephen,
Garrick?
maybe I'd like to tell a story. So I was in Argentina, in Buenos Aires. I was doing my article for the Law Society, and this is what happened. So we were representing, I was working for a small boutique law firm, international law firm. We were representing a big exporter of fish and calamari, Ricardo, I remember his name. And then the deal was with the Canadians. Okay, so first, so many mistakes. Like, so they didn't send the CEO, they sent a VP. So the CEO was expecting to meet his equal. So power distance is huge in Argentina. So he felt insulted, and he brought the lawyer. And of course, they were talking about terms and conditions of the agreement right off the bat of the deal. Cultural faux pas. You need, I mean, sophisticated international people know that, but it's culture is the software of the mind. It's in your brain. No matter how you want to avoid cultural faux pas, you're going to do it. Because if you're sent as a corporate Canadian executive to do a deal and you come back and you don't talk about business, you're going to have issues. I can tell you another, not everybody are really sophisticated for that. Another example, he was a guest lecturer often in my class when I teach international business negotiation at law school, business school, and he's former VP J.R. Power, former VP of Canada Post International. And once he went to their CEO, said, I need to go, they had a deal actually with Argentina and another one with Italy. It's like, I need 3 weeks to do those 2 deals because Canada Post was selling technology to, our technology to other postal services in other countries. It's like, I need 3 weeks and I need my wife to come with me. She's Italian, there's a lot of Italians in Argentina and Italy too. And so the CEO is like, what? You need like vacation? And so anyway, all this to say, he was sophisticated. He knew how to close a deal in international context. He took 3 weeks of vacation, paid for everything himself, went, closed the deal, came back, say, I told you, I asked you, that's what I wanted. I know the culture, I know how to close deals there. So this is not like he had to take his own time, of course, after that he was compensated. But those are war stories, true stories. It might not be, I don't want to generalize, like Ed said, it not always, like my article, I was focused more on international transaction because I saw the value, or in the context of the government, I can see even more the value because bureaucrats are not always, government lawyer and bureaucrats are not always accountable to the minister, so I can see the value, but those are stories where I can see like, it can be value, especially in the global economy.
I want to just throw one thing out there where I think, get Ed's reaction and the others, where mediator, call him facilitator, call him conciliator, but a neutral third party involved in a transaction can add enormous value, and that's in the area of what some of us would know as the concept of reactive devaluation.
Yeah.
Is that so for those who aren't familiar with the term, reactive devaluation refers to, for example, your next door neighbor has just bought a new Lexus, and he calls you over to look, and he's enthusiastic and excited, and he says, it's the best car I've ever owned and driven. You should really check out this car next time you're going to buy a car. And of course, you hear that and you say, well, it's coming from my neighbor. He's really excited. I'll go check it out. Contrast that with a situation where you show up in a Lexus dealership having never heard from your neighbor, and the salesperson tells you this is the greatest car that's ever been created. You got to buy one. We reactively devalue that input because of where it's coming from. So as mediators, we call that reactive devaluation. One of the things we do as mediators is we'll go into one room in a litigious dispute. We'll get something that party might be prepared to do to settle the case, but we don't walk into the other room and say, hey, they'll pay you $250,000 if you'll settle. What we do is we say, I've thought about this, I've talked to both sides. If I could get the other side to consider paying you $250,000, what do you think about that? The other side says, well, I don't know. We talk about why they should consider it and so on and so forth. But they're not immediately devaluing the suggestion because it comes from the other side. And I imagine, and I know from my own experience in transaction work, where you hit a roadblock on some issue, if the other side's lawyer is recommending something, it may not land as well as if it's coming from a neutral. Any thoughts on that? Or you're so smooth in your delivery that other side. Go ahead. Mary Ann. Mary Jane, sorry.
Very good point. And sometimes it's just having that presence.
But you can have creative input. You can think of some solution neither of them have thought of and suggest it, if you've got deal experience.
And in your case, you lend credibility to the process, so the
subject
principals
matter
as well as the lawyers are going to pay attention to what you have to say. I get that.
Yeah. You roll the process.
Yeah.
That's how it works.
Sometimes, I agree, sometimes that's built into the existing sort of team in one way or another. Sometimes you go outside and you do what you have to do. So
I've been brought in on a couple of occasions where there was a partnership that had gone on for 20 years. Not huge businesses, but big enough. And the partners had decided it was time to go their separate ways. But do we sell and divide? Does one buy out the other? How, does one stay in as a silent participant, the other guy? So these were issues that they had identified, and they went to their accountant, who said, in one case, it was an accountant who said, well, I can't act for either, like, I have to be neutral. I act for the company. We are both long-term trusted clients. And that accountant suggested they bring me in, and we had a series of a couple of meetings. First, without any lawyers. They agreed that let's just talk. The spouses were involved because for tax reasons, they owned 25% each. And we worked out the terms under which one would buy out the other. And then I met with the lawyers and they papered the deal. And then an issue arose after the fact. And I was brought back in and we resolved that in a half day. And the deal was done.
So you see that, I think that's a good example. And the example is where you've got partners or two clients who've been engaged with each other forever, and their lawyers have been engaged with each of their clients forever, or their accountants, and either there's a conflict, or even if there isn't a conflict, the identification of the professional with the client is so strong that it makes sense to bring a different view in, and I get that one completely.
Right. You had a comment? Sorry.
Also, rule for deal mediation, when you have two parties who value the transaction totally differently. I do a lot of negotiations for the government, and there is useful for both sides to have the mediator there. Also, if nothing else, and to tell to their own constituents where they arrived at.
We don't have any power. I mean, there's no reason for the parties to be afraid of the involvement. All we have is powers of persuasion, powers of nuancing communications, powers of maybe thinking creatively outside the box of what the parties haven't thought of. And God,
That's a lot of power.
Well, it is, but if they don't need it, we can be underemployed.
Well, but it's kind of like the Heisenberg principle. You don't have power, but once you introduce something, the dynamics change, and it actually becomes, you can have a lot of power without having any
But
power.
in terms of the challenges, I talk about it in my article, and I think it's common sense. Like, of course, the mediators are not perfect. Like, a deal mediator will not be perfect. So that's why you need to be trusted by the party, because you will have an influential role. But put yourself in the shoes of a mayor, you talk about public sector, or a minister, and you have to rely on information only from one side. Because in private sector, every time we're negotiating a deal, private sector get frustrated. They don't understand nothing from our reality. They call the minister office. They complain. They don't have to follow the chain of command, so they can call the minister office, said, it's not working. We're supposed to close the deal. Your bureaucrats don't want to do it. But they don't know there's specific laws, Financial Administration Act, a lot of things we cannot do. Otherwise, that will be viewed as illegal. We don't have the authority to do so. So if there was a mediator who understands that context, where the minister or the mayor of the city can go turn back and say, no, I was there, I noticed, it was, in terms of negotiation, it's not just win-win or win-lose. The dual concern theory is like, it's not a good way to see negotiation. It's based on power-based, right-based, and interest-based interests of the parties. So that's the role of a deal mediator, to explain the right base. They were invoking good rights, and in terms of interest, that makes sense. They tried to mitigate the power struggles. I saw it. It will be like very useful for, in that context. And again, it's a lot of money. Like, the biggest agreements are signed between public sector, entity and private sector. So.
We only have a couple minutes left, but I wanted to introduce one other area where I see value in this, and that's in what we call the family enterprise situation. Mm-hmm. And sometimes we're talking about multi-billion-dollar family enterprises where the founder of the business, the father, is hitting that age where he's, they've got to be thinking about what's going to happen in the next round, and you've got 4 children. and one child is, in effect, been groomed to take over the business over the last 20 years. Another child works in the business in a subordinate role, but reports to the patriarch or the matriarch in the family. You've got a third child who's practicing law very successfully, has nothing to do with the business, and you might have a fourth child who's at 45 still finding themselves trying to write plays or whatever. I mean, I'm sketching out a situation that everybody in the room has seen that situation in their professional or personal lives. And now the parents have figured out how to keep it all together while they're around. But now they're in their late 70s, and they're starting to think about what's the glue? How's this going to work? Who's going to make decisions? Who's going to make sure that child number 3 and 4 are looked after and treated fairly? How do we make sure that the child running the business is making distributions? All these things have to be worked out, and they have to be worked out, and generally in too many cases they're not worked out, or they're only thinking about the tax planning and the estate planning legal aspects of the relationship. And here's a case where I would suggest that lawyers are not the best people to sit with the family because they're not dealing primarily with legal issues. That's been put in place. But now you need to figure out how are we going to have quarterly meetings of the family board? How are decisions going to get made? Is there going to be a neutral chair of those meetings? How are we going to train the members of that group to basically coexist for the next 30 or 40 years until they have to do the same thing with their children? And the skill set is you've got to know and understand the legal and financial framework to be effective as a mediator, but you got to exercise a lot of other skills where I don't think that you put the lawyers for each of those children together in a room, you're necessarily going to get a harmonious outcome.
Well, I agree.
I don't know if you ever do any of that, but
I do. I do some of that personally, but it just arises, I think it has less to do with your professional discipline and more with how you are perceived by the family. So what you're describing is a trusted advisor, a coach, whatever it is, but someone who the family has sufficient confidence
3 out of 4 of those kids may have confidence in you, but a total neutral who's had no history with anybody may have an easier time
sometimes
getting everybody on board.
That's still finding himself is going to get shafted.
Well, the point is they may not.
relate to me because I'm in that position myself.
They may not get shafted, but they're worried they're going to get shafted, and that affects their whole mindset.
Yeah.
Are we out of time?
Yes.
Lunch. I don't want to stand between you and lunch. I was at a couple other things, but thank you.
See you.